All right.
Thank you, Your Honor. Commonwealth rests.
All right.
Your Honor, the defense would move the court for...
So I'm going to stop you right there. A short recess.
If the court needs one.
I don't need one, but I will see you at sidebar.
What's going on? Welcome to Legal Minded Friends. Ziggy and I are glad to see you. Let's find out. We left off with the judge cutting him off. However, after they took a sidebar, court ended and they returned the following day. So let's see what he had to say.
You are unmuted.
All right. So, Mr. Jackson, yesterday you told me you would like 10 minutes for your argument. I'll hear you now.
Thank you, Your Honor. Your Honor, I'll be brief. The court must consider, after viewing the evidence in light most favorable to the Commonwealth, whether a rational jury could find the elements of the charges beyond a reasonable doubt. And here, the case that the Commonwealth has submitted to the jury after resting is insufficient to meet such a finding. There's no question but that with this particular prosecution in this particular case, no reasonable or rational jury could come to a unanimous verdict in favor of the Commonwealth.
The defense is making an argument for a directed verdict. Now, if you don't know what that means, I found a perfect case where a judge explains what this is. So I thought we'd listen to that and then we'll go back to hearing the arguments that the defense attorney for Karen Reed makes. So let's listen to that first.
We have a lot of folks here, and I think it's kind of incumbent upon me to help the folks who are here kind of understand what it is that we're doing, because this might seem a little bit different. Under Arizona Rules of Criminal Procedure, we call it a Rule 20 motion. It's a motion that can be brought by defense or by the court on its own initiative to render a judgment of acquittal based upon the review of the evidence presented. The rule states in part, on motion of a defendant or on its own initiative, the court shall enter a judgment of acquittal of one or more offenses charged in an indictment or information or complaint after the evidence on either side is closed, if there is no substantial evidence to warrant a conviction. And you heard both Mr. Davidson and Mr. Barker arguing about substantial evidence. I'm referring to State v. West, 226 Arizona 559. I was obviously I've been doing this for a while. I know that this motion is going to be coming. This is again State v. West, and it was a decision issued by our state Supreme Court, and it cites at head notes 3, 4, and 5. On all such motions, meaning the Rule 20 motions, the relevant question is whether, after viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. And I'll leave out the other sites. The Supreme Court continues, substantial evidence. Rule 20's linchpin phrase is such proof that reasonable persons could accept as adequate and sufficient to support a conclusion of the defendant's guilt beyond a reasonable doubt. Both direct and circumstantial evidence should be considered in determining whether substantial evidence supports a conviction. And I read to the jury the instruction on direct and circumstantial evidence. They go on, the Supreme Court goes on under head notes 6 and 7. On the other hand, when reasonable minds may differ on inferences drawn from the facts, remember, direct or circumstantial, the case must be submitted to the jury, and the trial judge has no discretion to enter a judgment of acquittal.
So this trial judge is explaining what an acquittal is, and in the Karen Reed case, that is what Alan Jackson is arguing for, a directed verdict which leads to an acquittal. And so let's hear what Alan Jackson's argument is for this directed verdict.
All right. So, Mr. Jackson, yesterday you told me you would like 10 minutes for your argument. I'll hear you now.
Thank you, Your Honor. Your Honor, I'll be brief. The court must consider, after viewing the evidence in light most favorable to the Commonwealth, whether a rational jury could find the elements of the charges beyond a reasonable doubt. And here, the case that the Commonwealth has submitted to the jury after arresting is insufficient to meet such a finding. There's no question but that with this particular prosecution in this particular case, no reasonable or rational jury could come to a unanimous verdict in favor of the Commonwealth. I want to, if I can, focus my argument on count 1, 2, and 3 and a specific element of each count.
Okay.
In each one of those counts, there must be evidence that the vehicle killed John O'Keefe. There has been no competent evidence presented in the Commonwealth's case that Karen Reed's vehicle actually struck John O'Keefe. There's been conjecture, there's been speculation, but no actual competent evidence. The Commonwealth's entire case relies on a theory built on the shoulders of a trooper named Joe Paul, who testified a couple of days ago. And his theory, according to the Commonwealth, is that John O'Keefe's arm was struck, he was spun around in sort of a pirouette, he was projected 30 feet to the left, hit his head on a curb or the road in the intervening time before coming to a final rest spot about 30 feet away. Everything in the Commonwealth's case, everything relies on that theory of damage to the taillight at the scene. If a rational jury could not unanimously determine that Trooper Joe Paul's theory is true beyond a reasonable doubt, then we believe the motion has to be granted. There is no competent medical evidence to support that theory. There's no competent physical evidence that the taillight could break and shatter in the way that they've suggested, and that the arm would not have any breaks or shatters or any damage, any additional damage. There's no evidence how getting hit in the arm could actually launch a body 30 feet, as per the Commonwealth's theory. And there's no evidence how a body hit by a 7,000-pound SUV could sustain no injuries from the neck down, which we just heard this morning. The evidence before the court, the only evidence that is before the court, is that the Commonwealth's own medical examiner does not believe this is a homicide. And she went on this morning to say that in her expert opinion, the injuries are not classic pedestrian injuries. And they are, every single one of them, consistent with a physical altercation. Calling a witness to simply espouse an opinion like Trooper Paul did that belies science, common sense, or even logic, that's not enough to get the case to the jury. The light most favorable to the Commonwealth does not mean that the court must believe the Commonwealth's witnesses. What it means is that if there is a rational controversy in the evidence, the court must accept that evidence that favors the Commonwealth. But here, there is no rational controversy. As put or expressed in Commonwealth versus McCormick, it's a 2023 case found at 491 Mass 848, pinpoint site 860, quote, where the Commonwealth's evidence is entirely circumstantial, it cannot meet its burden if the evidence equally supports inconsistent propositions, as resolution of such a case necessarily requires conjecture or surmise. In our view, there is no question that there's no rational controversy related to the Commonwealth's theory. Trooper Paul's theory is by definition not rational. It's not reasonable. And it's basically based entirely on conjecture. And that's why, in our view, the court is required to find Ms. Reed not guilty of counts 1, 2, and 3. It's because each of the counts, as I said at the beginning, necessarily include an element that John O'Keefe was struck by Karen Reed's vehicle. Thus, if a rational jury cannot reasonably believe Trooper Paul's theory, it's the only evidence presented by the Commonwealth describing how Mr. O'Keefe possibly could have been struck, then Ms. Reed is entitled to an acquittal. Nothing else matters. Nothing else in the court's evaluation, nothing else in the jury's evaluation, nothing. Everything turns on whether or not the car hit John O'Keefe. And the Commonwealth's only theory of how that happened is from Trooper Paul's description. If the court were to deny this motion, then by doing so tacitly, the court is expressly endorsing Trooper Paul's theory of how John O'Keefe was struck, and we don't believe that that's rational. We don't believe that any rational jury would ever unanimously agree with Trooper Paul, and thus we ask the court to find Ms. Reed not guilty at this time.
Okay.
I'll submit.
Your Honor, if I may just, we have a written motion for the court to act on pursuant to that argument. Here's what copy.
All right, I will hear you, Mr. Lally.
Yes, Your Honor. Surprisingly, I would disagree with counsel's
So let's leave the comments out.
Your Honor, as far as the comments, all I was going to say is that I would submit to the court that,
Is this surprisingly that I took issue?
and my apologies for that. What I would submit to the court, Your Honor, is that this case does not rest and fall with the testimony of Trooper Paul. Trooper Paul's testimony, while important, when taken in conjunction with the remainder of all of the other witnesses and all of the other testimony that the court has heard, I don't want to minimize it, but at the same time, that is not the only evidence that the vehicle struck Mr. O'Keefe or interacted with Mr. O'Keefe. So what the court has, as far as the physical evidence, next to Mr. O'Keefe's body, the one sneaker in the location of the curb, the glass, the drinking glass that Mr. O'Keefe is seen walking out of the Waterfall Bar at approximately 12:11 a.m. with, that is in the vicinity, the direct vicinity where the Canton police officers actually recover it early in the morning of January 29th. You have the microscopic pieces of the defendant's taillight, which was testified by Ms. Hanley to be consistent with pieces of the taillight from the defendant's vehicle that are within or embedded within Mr. O'Keefe's clothing. You have the remainder of the pieces of taillight, and this part is important in relation to Trooper Paul's testimony as far as the linear momentum, and it's all in the same sort of direction and path of all of the roadway evidence that he observed that's discovered in and around the area where Mr. O'Keefe's body was. The testimony from Ms. Valier, with reference to all of those taillight pieces and how they were able to reconstruct from the pieces that were found on the ground and then put back together, matching to that, but the taillight housing from the defendant's vehicle. The taillight housing from the defendant's vehicle, which has the victim's, Mr. O'Keefe's DNA contained on it, as well as the mitochondrial DNA testing of the hair that was on the rear right quarter panel of the defendant's vehicle, which also was matched or consistent with that of Mr. O'Keefe, his mitochondrial DNA, as well as the court heard from Ms. Chart from Voting Technology. You have the plethora of testimony from the various civilian witnesses from that particular night. You have the evidence of motive from the text communications, as well as the testimony of the children in this case as to the state of their relationship from the defendant's own mouth in those text communications and in those voicemails as to the state of their relationship. You have the testimony in regard to Mr. O'Keefe and his recounting of the state of their relationship and his numerous attempts to break it off with Ms. Reed prior to that day. There are arguments that continue throughout the afternoon of the 28th and seemingly into the 29th. You have the defendant's own statements that I hit him, that come from multiple sources, including firefighter Nuttall, firefighter Famati, firefighter McLaughlin, and Ms. McCabe. You have her statements to the paramedics in the back of the ambulance that the last time that she saw Mr. O'Keefe, they had gotten into an argument. You have the testimony in regard to Ms. Roberts and Ms. McCabe as far as the altercation or the verbal argument stemming from Ms. McCabe's reference of Bella's mother being a landmark, being someone that Mr. O'Keefe used to date just prior to that argument occurring in front of the house at 34 Fairview Road. With each and every piece of evidence that was presented throughout the course of the Commonwealth's case, including the forensic evidence, including especially one thing I would stress for the court is taking not only Trooper Paul's testimony, but Trooper Paul's testimony in juxtaposition to Trooper Garino's testimony as far as the vehicle or the native GPS locations of Mr. O'Keefe's phone in reference to the timing and in particular the information or data from the Toyota text string. Trooper Garino's GPS native location of Mr. O'Keefe's phone has that reversal, the same 3-point turn that Trooper Paul testified about, which occurs 8 minutes prior to the vehicle traveling 24.2 miles per hour for approximately 62 feet in a straight line in reverse. And as far as the testimony and the evidence that the court has before it, the court also has those backup testing videos that Trooper Paul conducted with the defendant's vehicle, so the court can see exactly what that vehicle looks like at approximately 25 miles per hour in reverse in a straight line. And what I would submit, Your Honor, is that there's more than sufficient evidence from a medical perspective, from a forensic perspective, from a civilian witness perspective, and from the investigation of this case as to all three indictments that the Commonwealth has met its burden, particularly under the standard before the court at this time. And for those reasons, I would request that the defendant's motion be denied.
Okay. All right. In the light most favorable to the Commonwealth under the prevailing Lattimore standard here in Massachusetts, I am satisfied the Commonwealth has met its burden. The defendant's motion is denied. So, Mr. Yannetti, are you calling your first witness?
Yes, Your Honor.
Okay, so let's bring the jurors in, please.
So the prosecutor has pointed out that the court, despite Trooper Paul's accident reconstruction, there is enough evidence that the jury could draw an inference from or conclusion that the evidence presented by the prosecutor in fact shows that Karen Reed's SUV did hit Officer John O'Keefe, and the judge was satisfied the Commonwealth met their burden. It is important to note that the decision for an acquittal can only be made on the clear weight of the evidence. A court cannot weigh the evidence or make a determination on the credibility of the evidence. That is for the jury to decide. Let's watch part of the other trial where the judge did make a directed verdict. After watching that, let me know your opinion. Should the judge in the Karen Reed trial have allowed the statements in, "I hit him, I hit him, I hit him"? Is that 3 times? And how could any reasonable person find Karen Reed's SUV hit John O'Keefe? Should the judge have considered the flawed investigation, which I discussed throughout my other videos? Just to prep you, you may recognize this case as the case against Michael Turney, a police officer out of Arizona whose stepdaughter went missing. You can find this case on the Law and Crime Trials if you want to watch the full arguments put forward by the prosecutor and the defense when they asked for a directed verdict. Though I must tell you, I had to put a lot of effort into this little clip that I'm going to play to clean up the sound, as there was a great deal of muffled background noise. So I just want you to see this judge's rationale. And I do question why the judge in the Karen Reed trial didn't use the same thought process or share her thought process. So let's have a listen.
In that Gerlaw decision, they cited Perkins and Boyce on criminal law, a Harvard Law Review article, which I would never cite, but they did. The rationale, but this language is particularly critical here in this analysis, Your Honor, because we have to understand the purpose of this rule. The rationale for the corpus delicti rule was a realization that confessions may be untrustworthy because of involuntariness due to improper police conduct or unreliability due to the mental instability of the accused. That's not even their position here. Their position is there hasn't been any police misconduct that led to an untrue confession. In the Gerlaw case, Your Honor, that defendant confessed to killing the victim in that case, but it wasn't recorded. It was 1980, they didn't record his confession. So you had a detective testifying, this is what he told me. So the issue was there evidence independent of that confession to corroborate it? Well, that's the purpose of the rule. But it doesn't serve a purpose in this case, and it doesn't apply in our factual situation. Therefore, any confession, admission, which they claim doesn't exist, any statement that this defendant made can be utilized to prove this case. Thank you.
Thank you, Mr. Amordino. Ms. Hicks, I will give you the last word. Just a moment, Your Honor. Judge, turning first to the corpus issue, the case law says that that the term confession can be used interchangeably from statements that are made throughout the case. So we would be requesting not just, clearly there's been no confession here, but any statements that are possibly inculpatory to be suppressed. And that's based off of State v. Jones, 198 Eras 18. Judge, Mr. Imbordino stated that circumstantial evidence, that the state has presented enough circumstantial evidence that Mr. Turney has committed murder. But the only circumstantial evidence that they've presented during this trial is evidence of his character, not of a crime that's been committed. He said, you know, he was the last person to see Alyssa, but we don't know that. We don't know who the last person was to see Alyssa. And that's, obviously it's horrible that there is a young woman who is missing, but it's not Mr. Turney who's responsible. Finally, Mr. Imbordino mentioned that with Rule 20, the evidence must be viewed in a light most favorable to the prosecution. And while that is true, the evidence must be more than just a scintilla of evidence, which is all that the state has presented here. So thank you.
Thank you. I have considered the issues raised by the defense and the state's responses to those. Taking the corpus issue first, the court has to consider the evidence that is before this jury and exclude from that consideration the defendant's statements. While there are cases that do suggest that the corpus rule is limited to confessions, Ms. Hicks is right. There are other cases that use the term statements. So when looking at this case without the defendant's statements, the court has to make two findings. Is there a reasonable inference that Alyssa is dead? Or could the jury make a reasonable inference that Alyssa is dead? And the second question is does the court or the finder of fact have the ability to make a reasonable inference that Alyssa's death resulted from the defendant's conduct? The court has considered the evidence presented without the defendant's statements. The court finds that there is a reasonable inference that Alyssa is dead. I find that this court could make that reasonable inference and that the jury could make that reasonable inference. The second question is there a reasonable inference that Alyssa's death resulted from the defendant's conduct? There is really no testimony about the defendant's conduct in relation to Alyssa's death. The defendant raised Alyssa, and the court is not here to decide if his parenting style was appropriate or inappropriate. The court's not even deciding if the defendant killed Alyssa or not. The court is deciding whether or not a reasonable inference from the evidence that has been put before the jury, excluding his statements, shows that a reasonable inference can be made that the defendant caused or the defendant engaged in conduct that resulted in Alyssa's death. The court is unable to make that finding. It is ordered granting the defendant's motion to dismiss based on the corpus delicti rule. The second question is whether or not substantial evidence exists to warrant a conviction. In some ways, I could just skip this and say the issue is moot because of my ruling on the corpus issue, but for purposes of the record, I'll make the finding anyways. There is evidence in the case. I am not here to suggest that the state has put forth no evidence. There is evidence. The court has to determine whether or not there is substantial evidence. And the evidence doesn't have to be direct evidence. It can be circumstantial evidence. There is circumstantial evidence in the case. The question then becomes, is it substantial that would warrant a conviction for second-degree murder? The court has considered the evidence and finds that substantial evidence does not exist to warrant a conviction. It's ordered granting defendant's motion for a Rule 20 judgment of acquittal.
I thought the last sentence from the judge, that the evidence wouldn't warrant a potential conviction, was interesting because, in my opinion, the evidence put forward in the Karen Reed case would also not warrant a conviction. So let me know your thoughts. By leaving a comment, you may help someone else that will read your comment. And of course, I love to read all comments as they are valued, and together we can be more informed. And this information may help you or someone you know. In the meantime, on this channel, you'll find a variety of playlists to suit every curiosity about the justice system. Please like this video if you like this kind of content. Hit the subscribe button and the notification bell if you want to be notified when I'm going live or upload another video. I'm Karen Cole from Legal Minded Friends. Information is power, meaning if you know something, you can make decisions that are right for you.